one title to the whole property, and possession is equal amongst all of the joint tenants. Joint tenants are typically between husband and wives or family members where they wish for it to automatically vest in the surviving spouse or sibling or family member. Now, I'm going to discuss a tenancy in common, and this you're typically going to see more when there are two individuals who are, let's say, friends or business partners or even brothers and sisters where they want to be able to leave that property to somebody other than the other property owner to which they're taking title with. Now, under a tenancy in common, the co-owners own undivided interests, but unlike joint tenancies, these interests need not be equal in quantity and may arise at different times. There is no right of survivorship. Each tenant owns an interest which on his or her death vests in his or hers, her heirs or devisee. The example of how this would appear on a deed would be John Doe, a single man, as to an undivided 3/4 interest, and George Smith, a single man, as to an undivided 1/4 interest, as tenants in common. And it's important to include that language at the end as tenants in common for that to actually apply. Similarly to a joint tenancy, any number of individuals can take title to property as tenants in common. However, the ownership division can be either equal or unequal, and a separate legal title to his undivided interest is held by each co-owner, even though they all have equal rights of possession.
Jason, can someone take title to property other than as an individual?
Absolutely. Corporations, partnerships, trusts, and Florida land trusts can all take title to property, so it doesn't have to be specifically in the name of an individual. For example, a corporation is a legal entity created under state law consisting of one or more shareholders. The benefit of taking title to property as a corporation is that the land owned by the corporation cannot be attached for personal debts or judgments rendered against any of its shareholders. Similarly, a partnership is an association of two or more persons who can carry on a business for profit. A partnership may hold title to real property in the name of the partnership, with partners having an equal or unequal interest in the property. The next way that you can take title to a property other than an individual is via a trust. And a trust is an arrangement whereby legal title to property is transferred by the grantor or the trustor to a person called a trustee to be held and managed by that person for the benefit of the people specified in the trust agreement called beneficiaries. A final way in which people may take title to property and remain anonymous is through a Florida land trust. The Florida Land Trust is authorized under the Florida Land Trust Act, which allows an individual to own real property in Florida confidentially and anonymously. As trustee of the Florida Land Trust, holds legal title to the real property under the terms of a Florida Land Trust agreement. The beneficiaries of the Florida Land Trust, which are actually the owners in this case, retain 100% of the ownership rights and control over the real estate held inside the Florida Land Trust. The trustee merely holds legal title to the real property and cannot act without the written authorization of the beneficiary. For example, this is how Walt Disney acquired all of his property in Florida so that they could not take advantage of him by unfairly increasing the asking price just because they became aware of his intentions. If they had originally known, as he was buying up those tracts of land in Central Florida, that it was this one person buying it, they might have become suspicious, and then they might have tried to raise their prices artificially to prevent him from buying all the land that he needed.
The slide that you see right now is actually a summary schedule of all of the types of ownership we've discussed this morning. And my contact information will be on the next screen. So if you would like to receive this schedule, because I know it would be very difficult to read through all of it as we do the webinar, if you would like to receive this schedule, please send me an email and I will get the schedule to you. And we are ready to take questions this morning, so if you haven't already typed in your questions, please feel free to do so now. We have a question that, what is the best way to take title to my property to ensure it is protected from my individual creditors?
Sure, the best way to do that is going to be as joint tenants or community property. When you take title as joint tenants, it prevents judgments against the individuals from attaching to the property. So, for example, if you have a husband and wife who have a joint tenancy, what would happen is any individual judgments against the husband could not be applicable to the property because they are joint tenants and joint owners of the property. Homestead provides even further protection in this area.
We have another question. Should I ask for a warranty deed, which, if I understood you correctly, also is called a general warranty deed, or a special warranty deed?
Always ask for a warranty deed, as it provides you with more protection as a buyer. However, most builders, banks, and other corporate entities selling property will only provide a special warranty deed, but it never hurts to ask.
Okay, the next question is about quitclaim deeds. Does a quitclaim deed transfer title to the property same as a warranty deed?
Yeah, it sure does. But the grantor of a quitclaim deed is not providing any additional warranties to the grantee as to the effectiveness of title to the property like a grantor of a warranty deed, which is typically why you see it used in situations where it's just transferring ownership from two individuals who know each other to one individual, or from a parent to a child.
Okay, how can I buy property in Florida without my name appearing in the public records?
Well, there's actually several ways to do that. They can purchase the property in the name of a corporation, a partnership, a trust, or as I mentioned before, the Florida Land Trust is the best way to do it anonymously. Because while you can buy it in the name of a corporation or a partnership and your name won't appear on the actual deed itself, people may still be able to identify your name with the company that purchased the property by reviewing the state of Florida's corporate records, which are currently online and are free and available to everybody.
Okay, this seems to be the last question we have, unless we have another one pop up. How can I make sure that my children receive my interest in a Florida property that I own with my brother in the event that I die?
In this situation, Sherry, you must take title of the property as tenants in common, and also make sure to identify the property in your will. By taking it as tenants in common, you've established that you have an equal ownership, divided interest from your brother. Therefore, upon your death, what would happen is it would automatically become part of your estate, which would then be sent to your children or whoever else you provided for in your will.
Thank you so much, Jason. This morning, this has been a great presentation and very helpful to me. And I appreciate all the people who've listened in. And please join us for our future webinars. You can check out our schedule of those coming up. Thanks again.